Hello, you watching on the CBN News Channel or YouTube. Welcome to CBN's live breaking news coverage of a major Supreme Court ruling on abortion. This case stems out of Idaho. It's called Moyle v. the United States. Let me do a quick recap if I can. Essentially, Idaho passed a law back in 2020. It was called the trigger law, which went into effect in 22 whenever Roe v. Wade would potentially be overturned. And it made it a crime for a person to perform an abortion punishable by up to 5 years in prison, and also that medical practitioner would lose their license to practice. The federal government then came in and sued, saying that it violated a federal statute pertaining to emergency procedures and hospitals that received federal funding. There were multiple rulings, one siding with the government, others siding with the state of Idaho. The Supreme Court stepped in and agreed to hear the case while the legal arguments were still kind of playing out. It didn't fulfill the court process through the appeals, the normal route. Essentially, the court said today that it made a mistake in agreeing to hear the case and kicked it back down to the lower courts. We are joined by Brad Jessup. He is the Associate Dean of the Regent School of Law. He's going to be here to help break down and interpret what the ruling means today. So, Brad, before we get too deep into it, let me just ask your first impressions. What's your reaction based on this ruling today?
Well, it's not a terribly surprising ruling, and it's interesting that both of the big abortion-related cases that we were expecting this spring, the mifepristone case a couple weeks ago and this one, ended up not being really abortion cases. They ended up being procedural cases. And the court today, they did what lawyers call dig, which is dismissed as improvidently granted. They're saying we took this case, but now upon further reflection, we shouldn't be deciding it now. We're going to send it back to the lower courts. There's fact-finding that needs to be done. There are factual disagreements between the state and the federal government. And so in this case, like the mifepristone case, we don't actually have anything that directly deals with abortion, although for now, obviously, the federal government has won in the immediate conflict.
In dissecting the opinion, I believe the ruling was 6-3. Can you walk us through how it was split and the reasonings for the split, saying that this case should be sent back to the lower courts?
I think it's probably more accurate to say that the court was 3-3-3, which is fairly typical of this court. We find on many cases there's kind of a block of the Clarence Thomas, Sam Alito, Neil Gorsuch group on one side. On the other end, you have the Elena Kagan, Sandra Sotomayor, and Ketanji Brown Jackson on the other. And you have three who are kind of in the middle, Chief Justice Roberts, Justice Kavanaugh, Justice Barrett. And that's the way the court breaks down on this decision. The controlling opinion is what's called a per curiam for the court. No justice put his or her name on that opinion, and it's about a sentence long and just says this case is dismissed as improvidently granted. Period. We're done. But then you've got some concurrences and dissents that shows how the court splits. Justice Elena Kagan writes an opinion joined by Justice Sotomayor and Justice Jackson, who basically say, we'll go along with that. We'll allow this case to be dropped at this point because once we drop the case and remove our prior stay on an injunction, essentially that means for the short term, the federal government wins. But they go on to say, on the merits, we think the federal government wins. We think the federal statute has to preempt the state statute. You've got three on the other side, Samuel Alito writing for himself and Justices Thomas and Gorsuch saying, this is wrong. We should decide the case and the state wins. The federal statute does not preempt the state statute, although, the other justices suggest that there is a clear conflict between the two. And then you've got the three in the middle who actually decide the outcome, which is Justices Barrett, the Chief Justice, and Justice Kavanaugh, and they don't discuss the merits. They don't say whether they think ultimately the feds will win or the state will win. They simply say it's premature. There are factual disagreements between the state's position and the federal government's position. This has got to go back to a trial court to hold a trial and decide what the facts actually are. And maybe it'll come back to us. Maybe we'll decide it again later on, but for now it's premature. So the three who say it's premature and the three who say the federal government wins combines to be the 6 justices who say we're done. We're backing out of this. We're going to allow the federal statute to preempt the state statute for now, with 3 dissenters. But perhaps ultimately some of those 3 in the middle would end up deciding with the Alito Thomas Gorsuch group.
There's a lot that you just said that I feel like there's so many tentacles that we could just dive into. But real quickly, what I'd like to do is unpack some of what you just said. This federal statute that you're talking about, it's commonly referred to as EMTALA, and I have it here. It's actually called the Emergency Medical Treatment and Labor Act. And Brad, correct me. I'm going to try to just give a yeoman's explanation here. Essentially, that law, I believe, was passed in the 80s, and it was originally enacted to prevent what's called patient dumping. If you've had like a homeless patient waiting in the ER, you couldn't just take them to another hospital or dump them into another location. You had to perform the emergency medical treatment. So the federal government took this law after Roe v. Wade was overturned, and basically said the act that was established in Idaho only made a provision for the life of the mother. And from my understanding, this is the United States government said there should be a provision for the health of the mother if her health is at risk, if her fertility is at risk, and that's how this case started. Correct me if I'm wrong. Did I explain that okay?
Yeah, you did a great job of it. This Emergency Medical Treatment and Labor Act from 1986, when it was written in Congress, there was not one word suggesting that this would be a federal vehicle to require medical treatment that's illegal in the state. Congress wasn't thinking about that. It wasn't on the table. As you said, this was about not turning people away from hospitals because of their inability to pay. If I've been in a car crash and I'm bleeding out and they bring me into the hospital can't say, whoa, you're homeless, you're indigent, you're poor, you're not going to be able to pay our bills, we won't treat you. This federal statute was designed to do that. It was not written in a way that suggests, oh, you have to perform medical care that is illegal if a doctor says it's necessary for the patient. So just by analogy, what if the doctor says, well, this drug is needed that has not been approved for use in the United States, but they use it in Mexico, and I think that's what's needed to avert a medical crisis. The statute doesn't require the use of an illegal drug. Or if someone's life could be saved by, doing a heart transplant from another living person, well, that's illegal. You can't do that. The statute doesn't force everything that might be needed to deal with a medical emergency. It simply was designed to say, if there is a medical emergency, money can't be the determining factor. But after the Dobbs decision 2 years ago correctly found that the Constitution does not provide a constitutional right to abortion. So for 50 years, we had lived under the Roe Casey regime that falsely claimed there was such a constitutional right. Once that happened, the Biden administration issued directives to the states and said, you can't forbid abortions if they fall under this EMTLA, if they are necessary to preserve the health to deal with a medical emergency. And the dispute here is because the Idaho law only allows abortions to save the mother's life, and the EMTLA statute deals with medical emergencies, which could at least reasonably be broader than the mother's life, that the two are in conflict, that there might be an abortion. If you read EMTLA as requiring an abortion in some cases, that might conflict with the narrower exceptions to abortion under the Idaho law. And that's why they're seen as a conflict between these two statutes coming against each other.
And we should mention, it's not just Idaho. Other states have similar laws. I want to mention there was a U.S. District Court judge in Texas who wrote along the lines of what you were just saying, Brad, that the Biden administration position would force physicians to place the health of a pregnant woman of that over the unborn baby, which EMTLA is silent as to abortion. The Attorney General of Idaho said that this legal statute from the 80s says nothing about abortion. So how will this?
I'm sorry to interrupt, but it's actually stronger than that. There is in the definition of what is a medical emergency in EMTLA, there's a reference to preserving the health of a pregnant woman or her unborn child. So there's actually a suggestion that preserving the baby's life and health falls under that federal statute as well, that there's a duty not only to preserve the pregnant woman, but to preserve the baby as well. So it's completely removed from the idea that it forces abortions of the unborn.
That's an important clarification. Thank you for that. So my wider question is, how will this affect other states that have similar laws? What do you see? How do you see this playing out?
Well, what's going to happen at this point is we're going to go back to the trial court, and we're actually going to have a trial to focus in on the facts, because there are significant differences in how the federal government and the state interpret each other's laws. The federal government claims that Idaho would not allow an abortion unless the pregnant woman was in her last gasp of life, that just the death is instantaneous, immediate if we don't do an abortion. Idaho disputes that. They say, no, there could be a threat to a mother's life. It doesn't have to be 100% certainty, but there could be a credible threat that's coming fairly soon. And so Idaho says our law would allow more abortions than the federal government claims. On the other hand, Idaho claims that the federal law, when it talks about medical emergencies, would include mental health emergencies, psychological issues. And Idaho says, well, that's an exception you can drive a truck through, because all a woman would have to say to her doctor is, I will be traumatized if I don't have this abortion. It'll just mess up my mind forever. And the doctor could say, well, that's a mental health emergency, so under EMTLA we can do the abortion. And the federal government says, no, our statute doesn't apply to mental health emergencies. It only applies to physical medical emergencies. So there's a significant disagreement on what the two statutes do. And the court said, this has got to be worked out. We need to have a trial. We need to have a jury who decides what the facts actually are. And then we can decide if there really is a conflict between the federal and the state law. So how this will play out for other states isn't clear yet. We've got to see what happens at trial, and then there will be more appeals. But there are certainly some other states that have very strict pro-life laws. And if the eventual resolution of this is that the federal statute preempts that and allows more abortions than state law permits, then that would overrule any other state that has a similar law.
Brad, I want to read a couple of responses that came out today after the decision. But before I do, I just want to encourage anyone who's watching on YouTube, if you want to be a part of the conversation or if you have questions to ask, feel free to write them in the comment section and we'll try to answer those to the best of our ability. The first response I want to read is from the Americans United for Life pro-life lobby. They write that the court recognized, based on representations by the Biden administration, that Idaho may continue to enforce its pro-life law. The rights of pro-life doctors and nurses will be respected in all circumstances as federal law requires. The case will develop further in the lower courts, and the Supreme Court seems ready, willing, and able to review the case again once an appropriate factual record based upon the Biden administration's actual position is developed. So essentially what you have is religious groups saying that the federal rule was an example of a weaponization of government, forcing doctors and health practitioners to violate their conscience or sincerely held religious beliefs, which goes against the Religious Freedom Restoration Act. I also want to read real quickly the response from the Biden White House, which said, give me a second, I need to pull this up. Today's Supreme Court order ensures that women in Idaho can access the emergency medical care they need while this case returns to the lower courts. No woman should be denied care, made to wait until she's near death, or forced to flee her home state just to receive the health care she needs. This should have never happened in America, yet this is exactly what is happening in states across the country since the Supreme Court overturned Roe v. Wade. Real quickly, Brad, I want you to, the court, let me see if I can succinctly ask what I want to ask. You have the court weighing in on this decision, Moyle, and just a few weeks ago they made a ruling on mifepristone. How do you perceive the court's decision making on abortion now as opposed to 2 years ago when it overturned Roe and the Dobbs decision? Do you see any change? Do you see a softening? Do you see breaking?
No, I don't. I think there is a clear commitment from a majority of the Supreme Court to say that there is no constitutional right to abortion. So what we've been dealing with in these other cases are sort of peripheral issues around abortion. The mifepristone case was an administrative law case. Did the Food and Drug Administration follow the right procedures when it loosened up the guidelines for getting a hold of this abortion-causing drug? Nobody claimed that there was a right to abortion at stake in that case. It was simply about whether the administrative state had overstepped its proper role in government. In this case, you've got a conflict between a federal statute and a state statute and trying to decide whether the one preempts the other. Once again, there is no constitutional right to abortion in play here. I think at this point there are 6 justices, at least 5, but probably 6, who are firmly in the camp that boat has sailed. Roe has been overturned. Casey has been overturned. There is no constitutional right to abortion, so this is going to play out through statutes and regulations and that kind of law. And so we're interpreting those laws. We're not going back and reopening a constitutional question.
Brad, we should also mention that this was an epic session of the Supreme Court. There's yet another major decision, another major ruling that we're all waiting on, and that is the Trump immunity case. What is your expectation on the timing? Many political watchers are saying that it wasn't going to happen today because you have the debate and the court didn't want to inject its opinion and perhaps affect that debate. Do you see it potentially happening tomorrow or maybe even waiting until next week? And what do you gather from their decision to wait as far as how they might rule?
I haven't looked at the court's calendar in the last couple of hours, but last time I checked, tomorrow is the last day scheduled for an opinion hand-down day, which suggests that the immunity case will probably come down tomorrow. But there's still several cases outstanding. The court has been holding multiple opinion days the last couple of weeks. They've got a lot of things out there. If they can't get it all done tomorrow, then they may add some more days next week. There's no law that says they have to finish up by the 30th of June. It's just kind of a convention by the court that they generally try to finish the last case. They want to go on vacation. They want to be done with this. So they try to, by June 30th, have everything out, and then they come back the first Monday in October. So there's at least a possibility that they won't get to immunity tomorrow, Mr. Trump's immunity, that instead they'll schedule one or more opinion days next week. It's possible.
Brad, I think we're winding down. Is there anything else you want to add concerning this session of the court, today's opinion, or even the one that we were just talking about, the Trump immunity case?
Well, it's there was one odd aspect about this case. Yesterday morning, there was, I guess, what you could call a leak that this today's decision in the Idaho abortion case was briefly posted on the court's website and went away. And that, to many people, brought back memories of the Dobbs decision 2 years ago, which was leaked to the press in advance. But this is a very different situation. With Dobbs, the opinion was leaked in draft form months in advance, and it was clearly someone, we're still not exactly sure whether it was a pro-life or pro-choice person, there's arguments both ways, but somebody leaked that opinion trying to influence the court's outcome. That's not what happened yesterday. This opinion was finished. It had already been to the printers for the hard copy versions. But the court hadn't officially released it. Somebody made a mistake yesterday morning, some tech person probably, and pulled it up and then went whoops and pulled it back down again. So that's gotten a little bit of attention, but there's nothing nefarious there. It was just a mistake that was quickly corrected. That statement that you read a couple of minutes ago, I think it was from Americans United for Life, did point out, and the federal government conceded in this case, that there is federal law protecting pro-life doctors and nurses from having to perform abortions. So even if the Emergency Medical Treatment Act requires a hospital to perform an abortion, a particular doctor or nurse who finds that objectionable as a matter of conscience would not have to do it. They'd have to bring in someone else to do the abortion. And then, if just one final point, if I may, when you look at the dissent by Justice Alito, joined by Justice Thomas and Justice Gorsuch, they are arguing that even if there is a tension between these two statutes, that is, even if EMTLA would require abortions in some kinds of medical emergencies that don't fit the definition of threat to the mother's life under the Idaho law, their argument is that this federal law does not preempt the state law, even though normally under the supremacy clause of the Constitution, a valid federal law overrules, preempts, trumps, if I may, a state law that is inconsistent. But Justice Alito makes the argument that this law is telling the hospitals they have to take indigent patients is based on spending. It's based on federal money going to these hospitals, and it doesn't have anything to do with the states at all. And that in that context, a federal law doesn't prohibit a state law about what kinds of treatment are prohibited. That may end up being the big issue when this case comes back up again, as I think it certainly will.
Well, as you said, we're going to have to wait and see, because this will play out in the courts. It'll be appealed and challenged, and like you said, more than likely it'll be back before the Supreme Court. Brad Jacob with the Regent School of Law, thank you so much for helping break everything down. I'm glad that we had you here today to help explain everything. We're going to thank you again so much for watching our live coverage of the Supreme Court ruling today, and stay tuned for all of our programming on CBN News.